Retired law lecturer Peter Murcott has produced a booklet setting out his concerns over Michelle Haywood's Private Members Bill, which provides for safe access zones and protected public places. He joins me now in the studio. I guess if you've gone to the trouble of producing a booklet, you must have some interest, possibly even concern about the bill.
I have a great deal of concern about the bill because this bill will be a very serious infringement upon free speech, and the grounds for doing so have not been established. That's why I've produced this booklet, because I wanted to have a look as well to see how it had been approached in the United Kingdom, in England and Wales, though I have to say I'm not a supporter of the safe access zones there, but the law is infinitely less draconian than is what's being proposed here.
So, presumably, the mover of the bill has received support, first of all, to move this as a private member's bill, and also she will, I think, had support for second reading in relation to the bill. Do we get any clues from both those sittings of the House of Keys as to what the mover's intention is?
Well, I obtained the Hansard of what the mover had said, and one of the problems that I found was when I read through it, it didn't seem to me as it came up to the standard that ought to be required by the High Court of Tynwald. When you're going to move a new piece of legislation, I think you need to show that it is necessary. And to do that, you have to establish that the existing legislation is deficient in some way. The second thing is you need to have some very clear, compelling facts as to why it is necessary. In other words, you need to show that the legislation that you've already got has been found wanting, and you need to show also that there is a serious social problem which the existing legislation is not able to contain, and that requires a high degree of evidence. And what I noted was that high degree of evidence was singularly lacking.
Is this, though, a moving on from a culture which was primarily, in terms of politics, was male-dominated, to a slightly different culture which has, as we know, an awful lot more female members, certainly in the House of Keys and in Legco, than have ever been in the past. And perhaps they view things like intimidation as indeed, I'm not limiting this just to the women in the House of Keys, but the men as well. Perhaps they are recognising that the world is moving on, and there are circumstances where people can be quite intimidating, but the current law doesn't allow for them to be controlled in any way.
I hadn't actually thought about it in that way, but since you've raised it, I am no advocate, of course, of anybody being intimidated or harassed, alarmed, distressed, threatened. And the problem I come back to the problem here. If we were talking about some legislation that did not already exist to stop people being threatened, harassed or intimidated, I would wholly support it. But the fact is that we already have adequate legislation. I noted that in the leave to introduce address that the mover made, there were references to people being threatened and people being intimidated. The thing that was not shown, therefore, was if they are being intimidated, in what way has the existing law been shown not to work? And that was not demonstrated. There was no reference to specific evidence of exactly what had happened and how the existing law had been found to be defective. So there's no quarrel with the fact of the threshold. That's where free speech comes to its threshold, when it's going to move into intimidation or harassment, alarm and distress. But the threshold was not shown, and indeed a lot of the comments that were made were about stopping harassment and intimidation, and the bill actually replicates, and it reenacts some existing law, which is very puzzling, because if the existing law has been found to be deficient, why reenact it?
And, of course, it's quite an unusual thing, I think, to have a piece of primary legislation that basically enacts something that already exists in primary legislation. I mean, it's not unheard of, but it's an unusual thing to do.
Yes, and there's another problem. If you go to the Public Order Act 1998 and to the Act dealing with harassment of 2000, you'll find that inbuilt in those statutes there will be defences, and that's right and proper, that there always should be, because we don't want people to be criminalised needlessly. In the safe access zones part of the bill, those defences are not reenacted, so I take it that if a case arose under the bill, those defences would not be available, and that is always a matter of concern if you're going to have a just and effective legal system.
And presumably that would open up the opportunity for appeal. If one piece of legislation allows for one thing and the new piece of legislation doesn't, then presumably someone charged under this new bill, assuming it becomes enacted, could then point in law to another piece of legislation and say, well, if you charge me under that law, I would have these rights. Under this law, I don't.
Yes, I'm not sure whether it actually would allow that. It would be interesting to see what would happen if there was an appeal. But let me be issue specific here. When you're dealing with harassment, there is a defence of, it has to be raised by the defendant, but there is a defence of reasonable conduct, and that's not available in this bill. And so whatever your conduct was, I don't think you'd be able to raise that, because you're not actually if a person were charged under the Safe Access Zones bill, then that defence is not there. And I think, though I stand to be corrected, that the defence that someone wanted to raise of reasonable conduct would not be available. And that, in fact, there's only two defences I think you could raise under this particular legislation. One would be non-insane automatism. That means that you're either sleepwalking, or you've had a blow on the head, or you've been stung by a swarm of bees. That would probably constitute that. Or you could raise the defence of insanity, but unless those two can be raised, you actually are defenceless under the provisions of this bill.
Is it right that people should be able to enjoy their work without frequently having to run the gauntlet of protesters who basically disagree with the work and the role that they do?
This is where you've got a tension always in a free society. If you're living in a totalitarian society, then of course they will come down with some fairly draconian statements, and they won't worry themselves about these conflicts. But in a free society, what you have is you have to always decide where the boundaries of free speech come to an end, and where those boundaries are. And the way in which it's been discerned over the years is that it's when you start moving into somebody else's rights, in other words, their rights to be free from someone intimidating them or threatening them or harassing them, then your rights to freedom have now reached their limits. It's not easy to be able to discern those two distinctions, but it has to be done, and that's one of the things that a democratic society has to do. It has to struggle with those competing interests. A totalitarian society doesn't bother about that. It just simply puts a blanket ban on everything. And quite frankly, that's what my worry is about what this bill is doing. it's moving from what you would expect in a free society, and it's moving rather clearly into a draconian ban on everything, and that comes out in some of the provisions for the offences which are found in Section 10.
Do you think possibly the world in which we live, in which anything that's a fine balance or something that's difficult to judge, which causes inconvenience to decision makers, the general view is that we need to find a way to legislate away that inconvenience? Is that something that you've noted, or am I just being a bit fanciful there?
Well, I have noticed that freedom of expression is under attack, and I've also noticed that the boundaries of the restriction, the censorship, if you like, of the freedom of expression are growing and increasing. And that's why they would do well to go back to what the judiciary have said, where they've described what freedom of expression means, and not draw those boundaries too narrowly. For example, one of the phrases that you often hear is, "Oh, you can't do that because that causes offence." Well, some people would be offended by the fact that someone has a different point of view from them. And that has been a danger that I've noticed has been taking place in this millennium. And we've got to be very careful with that, because you've always got to look at these things objectively. And if you are going to pay undue attention to somebody being offended, then it means that another person now has got some rather dictatorial rights of telling you what you can say and what you cannot say. And what they often seem to mean by taking offence is they just dislike the fact that you've got another opinion from them, and they don't like the fact that you are expressing that opinion. That is far removed from the way in which a democratic society would normally work. And so I see this bill as part of a trend that's going on, and one that's got to be very firmly resisted, especially when you look at some of the non-criminal words that are being used in the offences that are created in this bill.
So the booklet that you've produced is snappily titled "Safe Access Zones, a Comparison Between the Proposed Manx Legislation and That of England and Wales." One of the things that members of the House of Keys are often accused of is following blindly the laws that are introduced in England and Wales, or Scotland sometimes, and sometimes further afield. But this isn't a case of following blindly what was introduced in England, is it?
No, I'm personally not in favour particularly of people having to follow Britain anyway. As far as I understand, and I've lived here now 34 years, I see the Isle of Man as having home rule, in many ways being distinctively different, and I think that they should always use that power to be able to legislate in accordance with the needs of the Isle of Man and not have their eye over the water. So, no, I don't particularly want Manx legislation to follow that of the United Kingdom. I'm not particularly in favour of the Safe Access Zones bill in England and Wales, but it has to be said, it is far, far less stringent and far less draconian than what we've got here. For example, in England and Wales, they have a non-criminal sounding offence called influencing. Now, that's very dangerous. Influencing has never been a criminal offence. It doesn't even sound criminal. The Isle of Man, in its Safe Access Zone bill, not only uses the word influencing without any question, without any hint of there being any violence or intimidation involved, it also makes it an offence for informing, doesn't sound criminal, or advising, or persuading. Well, everyday newspapers, Manx Radio and everybody else are doing just that. And so if you once establish that mere informing, advising, persuading or influencing without any reference to any intimidation or harassment, that once you establish that those things as they stand alone are now in the criminal sphere, then quite frankly, you've brought a free democratic society to an end. And this bill, as I see it, is the first step in that very unhappy direction.
In relation then to the offences that are created, I mean, you've touched on some there. I mean, what other offences are created by this bill?
Right, the offences are found in Section 10. The first thing, and I have to get a shade legalistic here, that there's something in this bill which is different from a lot of criminal legislation that I've seen. It says that you can commit the offence intentionally or recklessly. That's often in legislation. But then it says intentionally and directly, or intentionally and indirectly, or recklessly and directly, and recklessly and indirectly. Now, when you come to that last one, imagine how you're going to establish what you must and must not do if you are recklessly and indirectly not to influence someone. It means that you're not targeting it particularly against anyone in particular. So it uses this very unhappy start of recklessness and indirect. It then creates another astonishing offence over and above the ones I've just mentioned. It's in Clause 10.3. And it says this. It says that it is an offence for D, that's the defendant, to persistently, continuously, or repeatedly to occupy a safe access zone. It doesn't even tie it in with the protected person. So if you look at that literally, if you persistently, repeatedly, or continuously occupy a safe access zone, once you've established one of these zones, every single person who lives in that zone becomes a criminal. And every person who works in that zone becomes a criminal. And I notice that it doesn't even say it is an offence for the defendant repeatedly to occupy the zone with the intention of harassing someone who wishes. It doesn't say that. It just plainly says it's an offence to be there. Well, I don't know whether that's been thought through, but taken logically, then you're going to have an awful lot of people who are going to have to move house or change business. And what if they move into another access zone? And what about if the access zones get extended, because there's no limit on how far they can be extended ultimately? Are we going to empty the Isle of Man of its citizens?
And again, in terms of the extent, what is clear is in the Manx legislation there is a specific distance from a particular property, but the law then allows for this to be extended, and there's no restriction on how far it can be extended. So, on the one hand, they're setting a size for the zone, and then, but if we decide, we can extend it further if we like, and no restriction placed.
Yes, that's very worrying indeed, because we're coming really to, I think it's Clause 7 of the bill, which is how these zones are established. The first thing is, and this is a matter of concern, no justification has to be given for them to be established. They're established by the Department of Health, either on their own initiative or at the request of the person who is running, who is the occupier of other premises which are not owned by the Department of Health. They call that person the operator. So if somebody is operating a service, and it covers counselling, it covers advice and information, is occupying other premises, that person can apply for a safe access zone. And it's notable that that person does not have to give a reason why he wants it. He doesn't have to justify it. He simply puts in the application. They set out the nitty-gritty of the process and the procedure, but there is no obligation to explain why a safe access zone should be established.
And there's no Tynwald approval required for these, is there?
No. That's another worrying thing. When the leave to introduce was made, emphasis was rightly placed on the fact that a safeguard would be that these zones would have to be approved by Tynwald. Unfortunately, that has not been translated into the bill. When you look at the bill, you find that the way in which these orders come before Tynwald is actually third down the line from publicity. The first way, the most publicised way, would be what's called Tynwald procedure. That is, the department makes an order, but it won't come into force until it's specifically gone before Tynwald and they voted on it. Doesn't use that procedure. The second one would be the positive vote, or they have to affirm it. The positive vote procedure is not used. The one that they use is the negative vote. Now that is one that is the least effective, because what that means is the department makes an order, the order comes into force when it's made, and unless a member of Tynwald specifically raises the question and calls for a vote against it, then it will go through without any vote at all. And so it goes through in a rather an anonymous way. Now that does not establish a very good safeguard. In fact, it doesn't really establish any safeguard at all for effective scrutiny by the members of Tynwald. And so I'm surprised that what was said in the leave to introduce has not been translated into what we've actually got in the bill.
If, I'm doing ifs, buts and maybes here, if someone wished to protest about the Manx care overspend, for example, that's sort of health related. I mean, well, I suppose the question is, first of all, do the protestations, the intimidations have to be health related? And secondly, could, if that is the case, could something like the overspend of the health department be seen as something that could be covered by this?
I'm not sure how. I think that would be rather remote from the bill. I was interested when you said if somebody wants to raise an objection. Here's another problem with the bill. It is virtually impossible to raise any objection, assuming that you get to know that a safe access zone has been established and there are procedures whereby they've got to have lists of these they've got to have maintain a list of these safe access zones, and there is a procedure, although it's not very issue specific, that they've got to be brought to the attention of people, though it doesn't say how that's going to be done. But one of the things about these safe access zones, which is extremely worrying, is it introduces another thing into Manx legislation that I don't think ever's been there before. They have to be, the actual building to which the zone relates and serves, if you like, has to be anonymised. And so we're moving in the Isle of Man into what I might call semi-secret legislation. Now, if you want to raise an objection to the establishment of one of these zones, I don't know quite in practice how you would do it, because the bill says that you have to go by way of a petition of dalliance, and you can raise an objection to the premises. But how do you do that if they've been anonymised? You can't go before a court and take out a case, assuming you've got the money to do it. How do you raise an objection to premises that you don't know where they are?
Well, sadly, we are drawing to the end of the programme. What people can do, though, if their appetite has been whetted by what you've been saying, is there is a meeting this evening at the Legion Club. Can you tell us a little bit about that?
Yes, the meeting at the Legion Club is not specifically, obviously, about this particular piece of legislation. It's a general meeting about freedom of expression. I'm sure that this will get mentioned during that meeting. I shall certainly mention it, because we have got a very serious danger to freedom of expression in this legislation. And I hope that people will will examine this very, very carefully indeed, and will make their feelings known to their MHKs, because if they don't, then by default this legislation will get through, and then they will see exactly what it's doing when it actually comes to be enforced.
And the time of that meeting, was it 7:30?
I'm assuming so, yes.
Yeah, at the Legion Club. Organised by the Positive Action Group?
Positive Action Group, yes.
Well, I'm sure that if people want to Google Positive Action Group, they can find that. And yes, it certainly sounds like a very interesting topic that they've chosen.
It certainly is, and I think it's a very necessary topic, because the problems are far, far wider than this bill. This bill is just an illustration of a trend that is taking place throughout the British Isles, and it's one that we've got to resist at all costs.
That was retired law lecturer Peter Murcott. So what do you think? Is Michelle Haywood's bill really an attack on free speech, or just a sensible approach to deal with an occasional haranguing protester? Don't forget, this programme is available as a podcast on Manx Radio's website. For now, I'm Phil Gawne. Go to Mayo. Thanks for listening.